on YouTube. I'm going live again right now to address the issue that I was speaking about earlier with regards to the right that each and every last one of us, in spite of a criminal history, have in America to keep and bear arms under the Second Amendment to the Bill of Rights. What many people don't know, as I was alluding to earlier, is that the right that we have to keep and bear arms is, in fact, it's absolute. The right to keep and bear arms is absolute. Let me repeat that. In spite of what we have been told by those in civil service, in which civilians have incorporated, the right that we have in America to keep and bear arms is, in fact, absolute. It is absolute because the Second Amendment to the Bill of Rights signifies that it's absolute. When that particular amendment specifically said or says that the right of the people to keep and bear arms shall not be infringed, that term infringe, as depicted under that specific amendment, entails that no one in America or elsewhere has the authority under this Constitution that we have governed ourselves by to infringe upon that specific freedom, which makes the Second Amendment absolute. So when we have heard judges in the Supreme Court and elsewhere say that the right to keep and bear arms is not absolute, they are absolutely incorrect. The problem with those decisions that they make is we as people in general adhere to the nonsense because of what they say. Many people tend to do that because many of us do not have a significant knowledge of law and politics to the extent that I believe we all should. And speaking about that, I know that many of us know about what the Second Amendment to the Bill of Rights state, but for those of us on the off chance who do not, I'm going to quote the Second Amendment to the Bill of Rights verbatim. And that particular amendment specifically states, and I quote, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed," end quote. That is the entirety of what the Second Amendment to the Bill of Rights declares. How you doing? What's that? Bryson Block and Kevin Garcia. What's going on with y'all? What's going on, Heath? Heath Tellis. Appreciate it. I'm saying what's up to y'all too. What y'all got going on tonight? What's going on, Wild World 87? Okay, I see you, Debray. What's that? Debray Day 6834, Lemon No Fame. Bryson Blog, you have 38 views. Okay, I appreciate that, 38 views, even though it's showing 13 people in the chat according to this icon that I see up top. But I appreciate y'all stopping by though. Okay, yeah, well, shoot, man, or lady. I already ate dinner. I had salmon and mixed vegetables and some rice. And one of them Armour Palmer teas. Oh yeah, I'm good, Wild World 87. I'm just fed up with the bull crap going on in civil service that affects us all in a negative light because of many of us being ignorant to what's going on in the world. Oh yeah, well shoot, they say our brothers and sisters in China and Japan who eats rice and fish, that it's a heck of a lot more healthier than eating red meat that many of us have grown accustomed to doing here in America, for those of us who are from America. Yeah. My eyes are small. Infinity 2017. Heard that. I guess that's a compliment, I'm assuming. But I'll take it either way. Don't be mean, Infinity. Well, I guess, everybody has a right to freedom of speech or freedom of expression through speech in accordance to his or her own belief. Those freedoms are found under the First Amendment to the Bill of Rights and Articles 18 and 19 to the Universal Declaration of Human Rights. I've been streaming for a minute, but not here on YouTube to the extent that I would like to, primarily because I'm currently involved in other tasks. Who the heck is Ill Bill or Lil Bill? I don't know who that is, Tropic. Oh, no, you good, Infinity. It's all good. Where you remember me from? Or were you talking to Tropic up top? Oh, no, actually, I do not. Tropic, I have no idea who Lil Bill is, but now that you mention it, I guess since you brought it up, I can look it up. Let me see. You said Lil Bill, a cartoon? Little Bill, the cartoon character. What's going on? The Brady. You good, Infinity. Don't worry about it. I don't see how I'm dressed like him, though. I'm not dressed like Lil Bill. He doesn't have on what I have on. King 3. I don't know what that means in your name, since I'm fairly new to live streaming like this on YouTube, of course. Oh, I appreciate the thumbs up, the likes through thumbs up as well. He wears a lot. Sorry, what you mean he wears? He wears a lot of red or what? Yeah, I appreciate it, Bryce. You heard that, the Brady. The Brady. He says bad words. Talking about the Little Bill character. Oh yeah, I'm definitely better than Little Bill, whoever he is. Yeah, I don't really say bad words unless it's necessary to say them. Some people would consider certain words to be bad, but because of what other people perceive to be bad doesn't necessarily make it so. Yeah, I heard you, the Brady. Sorry to hear that, guy. Yep. I would play some music in celebration of your grandfather, but I don't think YouTube would take kindly to that from previous experience. So I would decline from doing that today. You good? No problem. Any one of y'all play video games or do y'all work a lot to where y'all don't have time to do things that you would like to do in your pastime? Yeah, I've been hearing a lot about this, what you call it, Call of Duty. I actually had the games for years, but I never played them. But I might play some video games later, but shoot, I'm currently watching the first season of Spartacus House of Asher. I had 3 more episodes to go. In addition to that, I'm straightening up the apartment that I'm in, cleaning up, washing dishes, stuff like that. After that, I have to finish doing some legal work and also to write a little bit more in the Star Wars book that I'm currently writing. For those of you who are interested in Star Wars, be on the lookout for that book whenever it gets published or whenever I finish with it to where it can be published. Has some good characters in that book too that I think many of you Star Wars fans will find intriguing. Play it as a good game. You're talking about, oh, I play Call of Duty Mobile. Oh, yeah. But the Call of Duty Mobile, that takes up a lot of, I believe, storage space on the phone, right? For music, in my opinion, you should play White Horse by Chris Stapleton. Yeah, I would play it, but here on YouTube, they won't allow that because of what they consider to be copyright infringement, not having the artist's permission to play their music on this particular platform. So it's not the same as like being on, let's say, Bigo Live or TikTok, where you can play music like that. And nobody really gives a crap as far as people that owns these social media sites. Yeah. Pale. Is that the name of an artist? Okay, you said of what? It's the name of the singer. Oh, okay. Pale is the name of the singer. And I believe the song is called Of. Oh, Play on the Phone. Okay, got you. Chris Stapleton. That name sounds familiar. I think I heard some of his music on American Idol or X Factor. Somebody was singing that. Okay, yeah. I think a lot of people have sang his songs. Who's your favorite singer? Are you talking about male or female, or male group, female group? I guess I can break that down to you just to cover every base here. My favorite female singer is, of course, Whitney Houston. My favorite male singer is Tevin Campbell. My favorite male R&B group is Troop. Female R&B group that will, I'm going to say SWV. Favorite rap artist, that'll be Tupac Shakur. Female rap artist, that's a tough one. That's up in the air. But it could be something to think about. RL, what time is it? Talking about what time is it here? DeBrede? If you're talking about here, it is 10:14 p.m. Yeah. 10:14 here. Same time for the most part. Oh, my favorite hip hop group would be Onyx. They number one. Number two would be Black Moon, and of course, number three, Wu-Tang Clan takes up that particular slot. Yeah. Yeah, I think we're in the same time zone, the Brady. It's 10:14 here as well. See? 10:14. Oh, yeah. Yeah, I was talking about politics and the right to have firearms and stuff, but I guess talking to you all is intriguing in its own right. So I guess what I'll start doing is probably making those videos and just posting them later. And then when I come on live, I chat with you all like I'm doing here now. Diddy the Gangster. Oh, what's going on with you? What's that? Savan? Believe I pronounced that correctly. Oh, I don't know. I don't know why Savan said Diddy the Gangster. But he could see the comments that you all posted. So perhaps that individual would answer that specific question. Tommy was trolling. Oh, man, it's all good. It ain't really causing none of us any harm, so. Miss Click. I have no idea who that is. Well, how long y'all been on YouTube? Or do y'all just pass through? Do y'all subscribe to any content creators here? If so, who do you all find interesting here on YouTube? I subscribe to a few people here on this app. I definitely subscribe to some of you all, even though many people that come into the chat doesn't necessarily have anything posted on their YouTube channel, but because you all, for those of you who have followed me, I definitely subscribe to your channel back. Do you play Roblox? I don't know what that is, so I'm gonna go ahead and say no, I do not. No, I don't know what that is. Never heard of it. I'm assuming it's a video game though. Yeah, no, I don't know what that is. But from the looks of it, some people on here play. They know what it is. Savan know what it is. I'm assuming. Infinity know what it is. Any one of y'all going to see that new Supergirl movie that comes out in the theaters in I think about 2 or 3 more months? Have any one of y'all saw the new Scream? Matter of fact, I could watch that tonight, come to think of it. Maybe I'll do that after I get. Yeah. Oh, yeah, I definitely play Grand Theft Auto GT. Hold up, GTG, or did you mean GTA? If you're talking about that, yeah, I play Grand Theft Auto. I also have a Resident Evil game, but I haven't been able to get off keeping a lady from stabbing me. Maybe I'll pick that back up. Oh, okay, gotta go. Gotcha. All right. Oh, yeah, I play Grand Theft Auto, the Brede. And I heard you say you gotta go. It's nice chatting with you, though. I appreciate you stopping by. Oh, yeah. Perhaps I'll see you again on this app at some point in the foreseeable future. All right. Have a good day. Yep. Cute. It's already 10:20. Yeah. I guess since nobody's asking any questions right now, I guess I'll keep on going along with what I was saying just to stick with the title of this particular live stream, which was related to, of course, our right to keep and bear arms being absolute in spite of what we've been told by those in civil service, in which has been accepted by many civilians here in America. One of the things that I realized, y'all, when I was studying law, or when I initially started getting into the judicial decisions that many of us are completely unaware of. See you next time, DeBrede. I realized that a lot of the content of a specific judicial decision has not been introduced to the American people to the extent that the bullcrap in certain opinions have been. And when I say bullcrap, I'm talking about things within specific opinions that in the judge's mind's eye justifies the infringement upon specific freedoms that we have, specifically the right to own or possess arms. In the case of McDonald versus City of Chicago, citation number 561 US 742, 177 LED 2D, 894, 130 SCT 320. And of course, that case was rendered in the year of 2010. On page 768 to that specific judicial precedent, the majority of the judges in the Supreme Court for the United States said, and I quote, "The right to keep and bear arms was considered no less fundamental by those who drafted and ratified the Bill of Rights," end quote. When I read that specific portion of that particular decision, the first thing that came to mind was, okay, what do judges consider fundamental rights to be? And that's when I came across Andrew P. Napolitano. Mr. Napolitano was a federal court judge. How you doing, Infinity? I see you back. A federal court judge who wrote the book titled, "It is Dangerous to Be Right When the Government is Wrong, The Case for Personal Freedom," which was published in the year of 2011. On page 121 to that specific book. See you later, Infinity. See you next time. Appreciate you for stopping by. Judge Napolitano said this, and I quote, "What the government ignores is that our right to keep and bear arms is a natural or fundamental right," end quote. So now we know that the right to keep and bear arms is a fundamental right. We know that. Judge Napolitano said that, and because his book was written in the year of 2011, we can surmise from that particular fact that Judge Napolitano was speaking about the decision rendered by the judges of the Supreme Court in the McDonald decision, which was rendered in the year 2010, 1 year prior to Mr. Napolitano's book being published. So now we know that the right that we have to keep and bear arms is a fundamental right. We know that. So then I started thinking, okay, what does judges say in their decisions about the infringement upon a fundamental right, specifically the right to keep and bear arms? So what I end up doing, y'all, I end up conducting a little bit more research because now I'm intrigued. It's something I always knew, but to hear judges say it, since people tend to put more emphasis on what a judge has said on behalf of the American people, as opposed to the American people, such as myself, saying it, I wanted to look for specific judicial decisions that specifically supported what it is that I needed those opinions to support. So I kept going. And then I come across a case of West Virginia State Board of Education versus Barnett. Citation number 319 US 624 87 LED 1628 63 SCT 1178. This case was written in the year of 1943. On page 638 to that specific judicial precedent, the judges of the Supreme Court for the United States said, and I quote, "The very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, a free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections," end quote. Now, when I saw that case and the judges specifically said that fundamental rights are outside the purview of majorities and officials. Now, we all know that when we talk about the majority, we're talking about primarily civilians. Let's say people are called to serve as pettit jurors during criminal trial proceedings. These jurors hear cases where an individual has been charged with the offense of possession of a firearm by a felon in a state court system, or possession of a firearm in commerce after felony conviction in a federal court system. So what these individuals do, they decide on whether or not they believe that a man or woman is guilty or innocent. In the process of deciding that, what do jurors do? For those of you who missed the point that I was making earlier, jurors actually vote upon whether or not they believe a man or woman is guilty of a particular offense or not. So that particular case specifically says that fundamental rights may not be put up to a vote because they depend on the outcome of no elections. What happens when, or you know what happened when some members of Congress or a legislator within the General Assembly of any state that we decide to fill in the blanks with when it comes to creating gun laws? Here's what happens. A member of Congress or some state legislator, they're in their office, they're at home, they're on their yachts or helicopters or airplanes that they purchase, of course, with the American people's tax dollars. They're in their home sitting next to a swimming pool, relaxing based upon what we have allowed them to have, and which they have taken without consent, of course. And they say, hey, you know what? I don't like the American people having firearms, so I think I'm just going to make a law. I'm going to write it up and I'm going to put it on the floor just to get my colleagues to side with me so we can have more control over the American people. Because if the American people don't have sufficient arms or armament, they're going to rely upon me, us, for their personal protection. And when they do that, it puts us in a position to call the shots, to build our personal gain, our political gain, financial gain, business-wise, spiritual-wise. That's what they want. That's what I believe happened. So a bill was written up And so a member of Congress put the bill on the floor before every other member of Congress, whether those members of Congress were with the United States House of Senate or, of course, the United States House of Representatives. And they put the bill up after they explained what the bill is about. And of course, some people give their okay with it, some people dissent. But when everything is said and done, do y'all know what they do with that bill before it becomes law, before it became law, before gun control actually came into existence here in the United States of America? Members of Congress, to include state legislators, put the bill up for a vote in order to make that bill law. But what does the judges say of the Supreme Court for the United States? It says that, and I will reiterate, fundamental rights may not be put up to a vote because they depend on the outcome of no elections. With that being said, why the heck would members of Congress put these idiotic gun control bills up? As a matter of fact, that case, hold on, let's go back. It was written in 1943. Hold up. I'm on to something that I didn't think about before, but I'm about to see something. What year was the National Firearms Act ratified? I'm actually asking Google so y'all can hear it. What year was the National Firearms Act ratified?
The National Firearms Act, or NFA, was enacted in 1934. It was the first major federal regulation.
Okay, 1934 is when the National Firearms Act was ratified by members of Congress. So when this particular decision came out, when it specifically said that fundamental rights may not be put up to a vote because they depend on the outcome of no elections, that in essence invalidated the National Firearms Act based upon judicial precedent. Let's just be realistic. That's a fact. If we're looking at it from the perspective in which judges have instructed us to look at their decisions. Okay? So West Virginia State Board of Education versus Barnett, it got rid of every gun law that was made prior to that particular decision being rendered by the judges of the Supreme Court. But let's say other gun control laws, right? Like the Brady Firearm Prevention Act, right? That was issued, if I'm not mistaken, in the year of 1968, which means that members of Congress, they totally disregarded the Barnett decision rendered by the Supreme Court judges for the United States when they went along with the bull crap. But then again, they could probably argue, well, we didn't know that the Second Amendment was a fundamental right at the time. Well, let's say that's the case. They know now. So why the heck do they continue to create even more gun control laws that impedes upon the Second Amendment liberty to keep and bear arms, in which we now know is a fundamental right by law, a right that they do not have any authority under the Constitution to infringe upon, to ignore, to keep people from exercising when they choose to exercise that specific freedom. Something to think about. And then they got the nerve to say, well, we're creating gun control laws to protect the public. I'm a member of the public. What does gun control laws do to protect me? Let's be realistic here. Forget relying upon emotion that so many other people have relied upon when they agree with these incompetent nonsense laws geared towards violating the very freedom that we have, which is necessary to the protection of every other freedom because of how they feel. I've told people this on many occasions. I've been shot before by an unknown assailant without provocation. But if any one of you were to tell me or ask me, should that individual be permitted to have a gun? The answer to that question coming from me as a man who was shot is absolutely yes. Because no matter how I feel about what that brother did to me, no matter what I think about him as a result of what he did, my thoughts and emotions do not change the content of the Second Amendment to the Bill of Rights when that specific amendment specifically said the right of the people to keep and bear arms shall not be infringed. Doesn't matter what I feel, doesn't matter what I think. It remains the amendment as it was initially ratified. And for those of you who don't like that, I would suggest you get together and establish a second constitutional convention and replace the Second Amendment with statutory provisions such as Statute Title 18, Section 922, since many of you rely upon that particular statutory provision to prohibit specific people from having guns, which, of course, you people have no authority to do. Unfortunately, many of us are not as educated as I believe we all should be in order to put people like you in your proper place when you step outside the bounds of your privileged authority given to you by us under the Constitution for the United States. There's nothing wrong with a man or woman having a gun. And many of you, specifically legislators, have the tendency of saying that you are in office to protect the kids. Yet what I've been hearing through these Epstein files is that many of you are the primary source of child molestation, sex trafficking children. But yet you claim that you want to protect the children. That is why you claim that gun control laws are necessary. Where the heck were these gun control laws at when I got shot? Nowhere to be found. But you know what actually saved me? It wasn't the freaking police, y'all. So many of you rely so heavily upon law enforcement personnel. It wasn't military personnel. It was the freaking gun that I chose to carry on the night that I got shot, which is exactly what kept my assailant at bay, keeping him from fully exiting his vehicle, running me down and gunning me down. Had nothing to do with the freaking police. Had everything to do with me exercising my Second Amendment liberty to keep and bear arms under the Bill of Rights. So don't sit up here and tell me and expect others to believe that the Second Amendment has no place for civilians in this country. It is us civilians who are attacked far more than congressional personnel, law enforcement personnel, military personnel, presidential personnel, personnel of the governor of a freaking state that we reside in. We are attacked far more than any one of those civil servants are. So for civil servants to sit up here and tell us that we are restricted to having certain armament, we are restricted from having high capacity magazines, whereas they do not feel that they are restricted from having the very things in which they tell us we do not have a freaking right to possess. But how can that be though? When we are the freaking electorate, when we are the ones who put them in positions of public trust to protect our interests under the Constitution and to defend those freedoms that we have from enemies, both foreign and domestic. It doesn't help us, y'all. Gun control helps nobody. And we can't keep relying upon gun control laws because of an offense somebody been convicted for in the past. First of all, we all know without a shadow of a doubt that a lot of people who have been convicted were convicted without due process of law. We know that many people are actually innocent sitting in prisons right now as I speak. So we cannot keep holding people accountable for what they have already been penalized for in a court of law in the past. That is an act of double jeopardy. You're penalizing somebody twice for the same offense. Double jeopardy, a violation of the Fifth Amendment to the Bill of Rights. In addition to subjecting one to double jeopardy, people justify that through the act of subjecting one to acts of discrimination. And we know discrimination is a violation of law, specifically the Civil Rights Act. So we have to stop discriminating against people with prior felony or misdemeanor convictions. I don't give a crap if the offense was for a violent or nonviolent crime. It doesn't matter. It's all in the eyes of the freaking legislator. For example, here in the state of North Carolina, if a man or woman with a prior felony conviction gets a firearm just to protect themselves and their children with, they're not out in society committing a crime with the gun. They're not doing none of that. They just have a gun for personal protection, target shooting, whatever the heck it is they choose to have the firearm for a lawful reason. Police officer pulls them over, run their name. Oh, you've been convicted of a prior felony. You're under arrest for the offense of possession of a firearm by a felon. Oh. So this person goes to court. And lo and behold, dumb people who are called to serve as grand jurors end up indicting these individuals for essentially exercising the Second Amendment liberty to keep and bear arms, which is a right that is protected under the supreme law of the land, which makes all those jurors who chose to penalize an individual for essentially exercising the right protected by law the actual criminals. It is not the individual exercising a right under law who is a criminal. In fact, people that exercise freedoms in which the law provides or permits them to are considered law-abiding citizens. People who disregard the law are the ones who are considered criminals, right? Correct me if I'm wrong. So if people disregard a person's right to keep and bear arms, which is protected by the supreme law of the land, does that not make you all criminals who feel that way? Because surely you are the felons of society in which you speak about so much. And then once the indictment is handed down, the individual goes to trial, and lo and behold, some other incompetent bozo of civilians in society, called to serve as petty jurors in this case, convicts the man or woman. Oh, we find you guilty of violating the law of possession of a firearm. How the fuck is a person in violation of the law when they are exercising a freaking right? When the heck did rights become illegal to exercise? And when did the violation of rights become lawful? Many of you have allowed those in civil service to warp your minds into believing things that are totally untrue. And it doesn't help when many of you allow your emotions to cloud your better judgment in these situations. You all have to stop putting these statutory provisions ratified by legislators in opposition of the Bill of Rights, Constitution, Declaration of Independence, and Universal Declaration of Human Rights above those documents. Those documents are the source of the rights that we have under law. So when many of you put more emphasis on what politicians say through the unconstitutional bills that they have passed in order to make law, you all make the Constitution obsolete. That is why so many civilians, from what I've heard, believe that we don't have any rights in this country anymore. The president is taking our rights. Congress is taking our rights. No one is taking anything. It's just that many of you have allowed them to operate outside the bounds of the Constitution, that they have been free to do things in violation of the Constitution, which does not support the exercise of our civil, constitutional, and of course, human rights. That's the problem. And it's baffling to me how so many of you have not yet realized what the problem is. And then we have, and I will say this again, a lot of content creators on YouTube, a lot of them. Like I said, I subscribe to a few of their channels. But I do, with the knowledge of law that I have, realize the contradictions in what many of them say. For example, you will never hear me say that it is illegal for a person to have a gun when I personally believe in the Second Amendment to the Bill of Rights and put that amendment above all laws that are in opposition to it. You'll never hear me say that. Whereas other content creators, they'll say that we have a right to keep and bear arms, and then they'll turn around and say, oh, you got to have a gun legally. Those two words do not correlate with one another. I mean, where did the word you got to have a gun legally come into play? If the Second Amendment to the Bill of Rights is the supreme law of the land, doesn't it make it legal for a person to have a gun, and not just have a gun, y'all, because when you look at the definition of the right to keep and bear, those words respectively means to either openly carry or to conceal carry. So we already have a right to openly carry firearms. We already have a right by law, the supreme law of the land, to conceal the firearms that we choose to own through the exercise of our liberty. We already have those freedoms, y'all. We don't have to pay some member of the sheriff's department $90 here in North Carolina just to file an application for a concealed handgun permit. I mean, get the out of here, permit. I hate that word. Word doesn't even fare well, y'all. If you look at the definition of permit as defined in the Merriam-Webster's Collegiate Dictionary, 10th edition, on page 863, that dictionary defines the word permit as, and I quote, a written warrant or license granted by one having authority, end quote. Didn't the founding fathers who created the Bill of Rights, the Second Amendment to the Bill of Rights to be specific, did they not have authority to do what they did? So if they had the authority to create the Constitution, which of course they did, that's all the freaking authority in the world that we need. We don't need any additional freaking authority. And I get tired of hearing a lot of these content creators say this as well. Well, look, when you go into a state, you got to make sure you have the appropriate license to carry your gun. Again, the definition of license as defined in the Merriam-Webster's Collegiate Dictionary's 10th edition on page 669 defines that word as this, and I quote, a permission granted by competent authority to engage in a business or occupation or in an activity otherwise unlawful, end quote. You see how I say to engage in an activity that's unlawful. If we all have a right to keep and bear arms, if we all have a right to conceal firearms and to openly carry firearms, why do we need a license for that when those particular actions under the Second Amendment are not unlawful? But I bet you many of you have never thought about that because many of you are so stuck on doing what those in civil service tell you because you are afraid of being penalized on account of what they have grown accustomed to doing and getting away with. Only because many of you are unfamiliar with the laws designed to protect your civil, constitutional, and of course, human rights. That's a problem that I see. Many people do not speak about our right of revolution. Rarely hear people talking about that on this app. I don't hear people talking about the right that we all have to jury nullification. Rarely hear it, if in fact I ever do, here on YouTube. Those are freedoms that we have. Two of the primary freedoms that we as civilians have in order to put those in civil service in check when they step out of line. I don't give a crap what people have misled us into believing because that is not what the law specifically says. We get a lot of these judicial decisions that we compel judges to side with our argument on. But the sad part about it is people still do not stand on the freaking opinions in which we compel judges to issue in a specific case. Take, for example, the gun laws of New York. When Judge Clarence Thomason, right for the majority in the Bruin decision, said what it is he said on behalf of the majority, the governor of New York still went against Supreme Court precedent. But that governor will have a problem if the civilians went against the executive orders that she created in breach of judicial precedent. And why should anybody or any resident of New York even care? Because no matter what they charge you all with, it still doesn't strip any of you of the right to jury nullification, meaning you have a right to disregard any law, rule, regulation, or policy issued by a civil servant that you feel is in breach of any of the documents that they took an oath to uphold and to protect from enemies, both foreign and domestic. We all have that freedom. And to speak more about jury nullification, let me give y'all the definition of jury nullification as depicted in the 9th edition's Black's Law Dictionary. On page 936 to the 9th edition's Black's Law Dictionary, the word jury nullification is defined as, and I quote, a jury's knowing and deliberate rejection of the evidence or refusal to apply the law, either because the jury wants to send a message about some social issue that is larger than the case itself, or because the result dictated by law is contrary to the jury's sense of justice, morality, or fairness, end quote. That is the definition of jury nullification as defined under the 9th edition's Black's Law Dictionary on, again, page 936. In spite of that definition, some of you may be wondering what type of legal authority is present to substantiate that specific freedom. I can tell you all that there are many judicial precedents which substantiates the right of jury nullification. And one of the main decisions that I love to quote is out of the United States Court of Appeals for the Fourth Circuit. Even though there are Supreme Court precedents such as Spark versus United States that speaks about that as well, but I love the way that Judge Sobolov out of the United States Court of Appeals for the Fourth Circuit presented the right of jury nullification. And that particular case, which was rendered by Judge Sobolov, is the case of United States versus Milan. Citation number 417 F2D 1002. Fourth Circuit, and of course, this case was written in the year of 1969. On page 1006 to that specific judicial decision, Judge Sobolov, in writing for the majority, stated, and I quote, "We recognize, as appellants urge, the undisputed power of the jury to acquit, even if its verdict is contrary to the law as given by the judge and contrary to the evidence. This is a power that must exist as long as we adhere to the general verdict in criminal cases. For the courts cannot search the minds of the jurors to find the basis upon which they judge. If the jury feels that the law under which the defendant is accused is unjust, or that exigent circumstances justify the actions of the accused, or for any reason which appeals to their logic or passion, the jury has the power to acquit, and the courts must abide by that decision," end quote. That case alone signifies just how much power we as people have over those within the judiciary of the United States government. So don't sit up here and continue to believe that judges have more power than we do, because they technically do not. They are our representatives. They represent our interests, not the other way around. And the sooner we understand that, the sooner we understand and stand on those facts, only then will we, based upon my experience, see the significant changes in this country that so many of us long to see. But here's the kicker about the right of jury nullification. We have the right, but judges don't want us to know that we have that right. How does that equate with national security, though? If the people do not know about the right that we have under law to do specific things to set the record straight when those in civil service step out of line. I do not like that. And based upon what I'm about to read to you all, this is why I say we all need to have a significant knowledge of law and politics. And not just accept with those in civil service to include other civilians who have adopted the nonsense of civil service as truth. Half the people, whether in civil service or not, they have no idea what the heck they're talking about. And one of the things that I used to say when I taught legal research to the students of my class is that a lot of people will tell you something about the law. But if that individual cannot direct your attention to a specific portion of law in which they have spoken to you about, you are to disregard what they have said as if meaning nothing. Nobody can sit up here and tell you what the law is if they have not seen in the law what they claim to tell you what the law is. But I'm not like that. Like I said, when I'm on social media talking about law and politics, best believe that I have legal authority to support everything that I say, regardless of what that is. Okay, the case that I'm talking about is the case, again, out of the United States Court of Appeals for the Fourth Circuit, is United States versus Muse, citation number 83 F3D 672, Fourth Circuit. And of course, that case was written in the year of 1996. On page 677 to that specific judicial precedent, Judge Marks, in writing for the majority, stated, and I quote, "Although a jury is entitled to acquit on any ground, a defendant is not entitled to inform the jury that it can acquit him on grounds other than the facts and evidence, i.e., a jury has the power of nullification, but defense counsel is not entitled to urge the jury to exercise this power," end quote. And of course, Judge Moss was citing Judge Sobolov in the case of United States versus Milan. Do y'all understand the reason why I say it is important that we know the law? We have to know it, because if we do not know it, how are we going to know when those in civil service are manipulating us into believing or doing things that the law does not permit we do? Like me, for instance, if I was ever on a jury, right, and the man or woman is charged with the offense of possession of a firearm by a felon, first of all, what I'm going to be thinking, which is what I already do, a person's past does not define their present, and it sure as heck doesn't determine their future. We know that, right? So why the heck would I look at a person based upon what he or she was accused of doing in the past and choose to penalize them on account of what they were accused of doing in the past, even though they already paid their debt to society for whatever it is they was accused of doing? Do I not recognize, do many of you not realize that when you do that to people, when you have done that to people, that you have violated the very laws designed to protect their freedoms? You violated their right to keep and bear arms on account of subjecting them to acts of discrimination, which led to them being subjected to double jeopardy. There's no way around it. And many people who convict these individuals claim that those individuals that they have wrongfully convicted are the criminals, and they still yet consider themselves to be law-abiding citizens. Get the uck out of here with that propaganda. That is total and utter bullcrap. And I'm going to go ahead and say something else about law and politics that many of you are afraid of saying. Many of you don't even know about what it is that I'm about to say, but I'm going to say it anyway, because I feel that YouTube puts me in a position to reach many people on such short notice. I am going to talk about the right that we have to revolution in this country, a right that was initiated by the founding fathers during the Revolutionary War of 1775. Because of the right of revolution, for those of you who do not know, we are able to celebrate Independence Day here in America every 4th of July. The right of revolution, as defined in the Black's Law Dictionary, 9th edition, on page 1439, defines that word as, and I quote, the inherent right of a people to cast out its rulers, change its polity, or effect radical reforms in the system of government or institutions. By force or general uprising, when the legal and constitutional methods of making such changes have proved inadequate or are so obstructed as to be unavailable, end quote. Let's think about this for a second. All these law enforcement shootings that we have seen that are totally unjustified in everybody's eyes, whether we want to accept it for the most part or not. When people have been done wrong, and they tend to, let's say, want to sue a police officer who subjected them to excessive force, or for some people's families, deadly force. The moment they file a civil suit in a court of law, what tends to happen for the most part is that judges will dismiss those claims under the notion of, let me give y'all the correct term, summary judgment. They will dismiss a case of that nature on summary judgment because they feel that police officers have qualified immunity during the course of doing what they do in an official capacity. I don't agree with that. The Constitution doesn't acknowledge that. Heck, the Civil Rights Act doesn't even acknowledge that nonsense. But because members of Congress have not got the heck up off their little freaking butts that are glued to the freaking seat and set the record straight when it came to the judges disregarding the Civil Rights Act and just doing whatever the heck it is they want to do in the Supreme Court, when they claim, oh, police officers, they're not to be held accountable for violating your freedoms and subjecting you to acts of abuse, neglect, or tyranny because they have qualified immunity. Members of Congress didn't stand up for us, people. And because they didn't stand up and set the record straight, the legal and constitutional methods in which the right of revolution says through definition was not only inadequate, but it was also so obstructed as to be unavailable. Hence, under those circumstances, we all have a right to revolution. And we all know what that right entails. What y'all think the Second Amendment to the Bill of Rights is for? Do y'all think the founding fathers won the Revolutionary War of 1775 with just bare hands and knuckles? Or little melee weapons like a knife or something? No, they had arms. That's what enabled them to win that war. That is what enabled them to procure their independence. An independence that we, for the most part, have been able to experience. You got to ask yourself, I'm pretty sure some of you are, well, what legal authority do you have to support the right that we have to revolution? One of the cases that I love going to, if not the actual Declaration of Independence, but judicial decisions, since so many of you look up to the Supreme Court judges, many of you feel that whatever they say, oh, it's just the law of the land, no exception. That's bullcrap, but because this decision correlates with the definition, in which the definition correlates with the actual verbiage in paragraph 2 to the Declaration of Independence, I am going to accept the Supreme Court decision as if it was the law. And that decision is American Communications Association versus Dow. Citation number 339, US 382, 94 LED 925, 70 SCT 674. That specific case was written by Associate Justice Jackson in the year of 1950, who in turn was concurring in part and dissenting in part of that particular decision. But this was associated with, and we can surmise, the concurring decision because he was citing Abraham Lincoln's inaugural address of March 4th, 1861, as support for what he said in this specific decision. And what he said is found under footnote 12 on page 440. And that is, and I quote, "This country, with its institutions, belongs to the people who inhabit it. Whenever they shall grow weary of the existing government, they can exercise their constitutional right of amending it or their revolutionary right to dismember or overthrow it," end quote. So if we have a right to overthrow the government, right, why the heck is it that members of these governmental institutions had created statutory provisions that outlaw the overthrowing of government? Many of you didn't even know anything about this decision. Heck, you probably didn't even know about the definition that's defined in the Black Sloth's dictionary when it comes to the right of revolution. Heck, many of you didn't even read paragraph 2 to the Declaration of Independence. So you have no idea what the heck the law is and what it's pertaining to. But I do. I know many of you are not going to study law for 20 years of your lives as I have. So what I have decided to do, because I feel it is my duty and responsibility as a human being or American citizen, to convey whatever legal knowledge that I have accrued over the years to you all, because I know that you all don't have the time to study what I have studied to the extent that I have studied. You all have jobs, you all have responsibilities, families, children, businesses. You all don't have the time to study to the extent that I was given the opportunity to study. So it's the least I can do, or the least I feel that I can do with what I have, to convey specific information to each and every last one of you, to put you in the better position to where you can ensure checks and balances when those in civil service overstep their bounds under the Constitution. With that being said, I'm going to close this live stream. But before I close, I want to say again to all of the people who came in to converse with me, I appreciate you all coming by. I hope you all have a nice day or night, depending on where you are in the world. And until the next one, I will see you later. And for those of you who have not, who actually finds what I'm saying to be intriguing enough to subscribe to the channel, by all means, feel free to do so. And if you have any questions pertaining to law, reach out to me in the DM, send me a message, and I will be sure to give you not only the answer to your question, but I will also convey legal support to substantiate the answers that I give to the questions that you pose. You all have a good day.